Hey everybody, today's estate planning question is whether or not a naturalized U.S. citizen can name non-citizen beneficiaries. Before we get there, however, I'd like you to consider a friend who may be going through a what-if scenario that creeped into their lives, but they were fully prepared because you shared this video with them. We would really appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please share your questions with us, and we're going to do our best to get back to you so that together, maybe we can help folks before something happens in their lives. Back to the question. Naturalized citizen. First off, is a U.S. citizen. Even though you were born elsewhere, you now have the same rights and privileges as any U.S. citizen. Creating your estate plan, you can designate, as can a U.S.-born citizen, create an estate plan designating whomever you choose to be a beneficiary. They do not have to be a citizen, resident of the United States. One major caveat, I would say there's two things to consider. First, if you introduce a will into or if your last will and testament is your core plan as opposed to a trust, the will is going to go through a surrogate court, a probate court in the United States. There's going to need, the U.S. court is going to need certain things that may include signatures from folks who are not in the United States. That can complicate things a little bit because to get a proper notarization, they may have to go to a local embassy, etc. That is just sort of an extra hiccup when you're dealing with international beneficiaries. So you may want to consider a trust for your estate plan. After all, you are a U.S. citizen, and based on your net worth, it might be the appropriate plan for you anyway. However, if you are going to make distribution to beneficiaries who are not U.S. citizens, if you have an intention of providing them additional protections, that would typically, which we do routinely for most of our clients, I would say 99% of the time, it would routinely require that you create a trust for the beneficiaries. Because you are beneficiaries, and in this circumstance, the question was about Canadian residents, citizens. And I'm sorry, I'm jumbling around here a little bit. If you want to provide those protections, you would create a trust for those beneficiaries. However, if there is a non-U.S. citizen as a beneficiary of a U.S. trust, there needs to be a U.S. trustee managing that trust. So based on all of the parameters and what your wishes are collectively, you have a few options. Just know that there are some restrictions if you want those extra protections with a U.S. trust, if you have a non-U.S. beneficiary. We hope that information was helpful to you or a friend. Please don't forget to share. And as always, take care. Bye-bye.